Good evening, everybody. Keith here. I'm going to give everybody a chance to get on here tonight for a little bit. Like I said in my last video, my next video I wanted to talk about ecclesiastical trusts, and so that's what we're going to do. And the first thing I want to talk about in regards to ecclesiastical things, blue is the color of ecclesia. So in your documents, your private documents, when we're making these up, if we construct them in the color of royalty, which is purple, and then autograph them in blue, that shows our capacity that we autographed in ecclesia. The capacity of the document itself is in regards to our, quote, royalty. And if everybody's got their pen and paper handy, one thing you should really research is Weiss's Concise Trustee Handbook. Weiss's, W-E-I-S-S''S, Concise, C-O-N-C-I-S-E, Trustee, T-R-U-S-T-E-E, Handbook. It's only about 99 pages long. I suggest you read it. It will tell you your position as trustee and how to manage that. First off, I want to explain trusts are started in two different ways. One way that we're all aware of is by the event, the behaviors. If I create an event where I give possession of a truck to my daughter and tell her I want her to keep that so that when her daughter becomes of age to learn how to drive and travel, she can use it for that. That's an express trust, and it's expressed verbally. If you write it down, then it's an express trust written down. If I just give it to her, I have to somehow express the intent of its use to create a trust. Understand that part. The second way is by operation of law. And when we talk about operation of law, we're talking about, basically, you hear everybody talk about all crimes are commercial. Well, that means anything that's done in a commercial capacity is a crime. And it holds true if you look at it in reality, because, like I said, all these court transactions are a transfer of Federal Reserve notes. And that transfer is the creation of a trust. The creation of a trust, as I explained last night, can be done in several ways. One of those ways, which is a will and testament. If we look at the defendant in these cases, he's always a decedent. He's a deceased testator. Okay? Learn this stuff. And it's his will that we're executing. That's what has to be determined, is the deceased testator's will. So when we go to these court cases, we accept the state's presentation of facts and plead guilty to those facts, accepting them upon the will of the deceased testator to his benefit. He's going to be the beneficiary. You're going to be the trustor. You're going to appoint executor. You're going to appoint the administrator as trustee and make the defendant the beneficiary. Okay? So that's the operation of law one. That's how a trust is created in law. That's why all these court cases you go to, it's the creation of a trust. If you play your part correctly to create that trust as the executor, then you do the correct assignment of the trustee to settle the accounts to benefit the defendant. That way there's no detriment to the defendant. Okay? Let's see here. Remember, all these court cases are also probate courts. If you look up the definition of probate, it's establishing a will, a future trust execution. So you're in these courts and you have to establish the will of a future trust execution. That's why, like I said, these 1099 forms have to be done in a certain timely manner, because some of them can't be executed until the trust is executed. In the meantime, it's just in the phase of a will yet, of a deceased testator. That deceased testator has to finally be dead. All accounting has to be done. All accounts have to be settled. Once the accounts reach a zero balance, then the trust is executed. Proceeds are paid forward from the dividends so people can appropriately claim the taxes and income. Claim the income and pay forward the taxes. That's how that stuff works. So, the word probate means to prove or validate. Every court you have to go in and prove and validate your side of the will. That's all it is. That's all it is. Probate is the procedure by which a will is approved by the court as valid and last will of a deceased testator, person of the will. It always also confirms the person appointed as executor in the will. As executor of the will, you just assign an arbitrator to settle all the accounts. Being a deceased testator, the account itself can no longer be used. They're admitting that the account is that of a deceased testator. So when you construct the will properly, upon the execution of the trust, the account itself is no longer usable. It's a collapsing of the trust because it no longer has any valuable use. The testator is deceased and confirmed upon the execution of the trust per his will. Understand that. So, when we talk about this ecclesiastical trust, back to the very beginning, the colors, the ink in purple as the body of the trust, that again, that's the body of the trust itself is the body of your ecclesiastical trust. It is your own private declaration. And one of the languages that's used in it is the colors of the ink. Okay? Another one of the languages of this document is your seal. Your stamp and seal. A lot of people are going to use their family crest and coat of arms. And that's going to be stamped up in the top right-hand corner. They're going to have a flag of some kind of military or merchant style up in the right-hand corner, presenting who they're presenting themselves as in regards to foreign entity, a national entity, and their purpose, their intent. Remember, everything in trust is revolving around intent, and that's how you establish trust, is some kind of communication of that. So if they see your flag and it's a flag of ill intent, there is no trust. They don't want to construct wills and trusts with you. They know you. They recognize you as an enemy. We have to show that we're not that enemy. In the construction and wording, the language of the trust itself, the words that you put on the documents, that has to show your intent in that language as well, as being that peaceful body going forward and carrying forth the will of all man as a responsibility of your duty to your fellow man in correct stewardship for equality of all man, for that commonality of being man. That's the basis of all your common law, which is your ecclesiastical law. A lot of people call the ecclesiastical trust a common law trust, a pure trust. Some even call it a private trust. Private trust is actually a little bit different, but we'll get into that in the next video. So basically, understand that the ecclesiastical trust is your own pure private document. Now, when we talk about putting it on the record, we don't put the actual document on the record. What we put on record is a verification, either through your witness, your first-hand witness to the document with a notary, or your first-hand witness performing a quorum of first-hand witnesses, at least 3 plus yourself, and then including a public notary, whatever it takes to verify that you do have such an ecclesiastical trust established. It has been viewed and it is known and will be verified in any court of law or equity. And that's all that has to be exposed. That private document always remains private, but you provide a recorded proof of verification. And that's the important document to enter into the public record through the county recorder. That becomes part of that trust. You make that a part of that trust. That's the physical body of the trust that you can present in a public commercial forum to show that you do have a valid ecclesiastical trust. And that's what befuddles them, because they have no access to that record. It's a private record. And the public shall have no access to private records. The private individual has access to all public records because they're public. But the obverse is not true. So realize that, and that's the importance of this ecclesiastical trust. It's purely private. Purely private, with verification. But again, like I said, with that quorum of witnesses, make sure that's a quorum of witnesses that are not biased. Don't just use family and friends. Those can often be considered biased, and therefore make a contestability of the validity of that trust. So when we do these trusts, make sure that we're using a good one to do is like the pastor of 4 different kinds of churches. You just got to use your head about this stuff. Have an ecclesiastical trust that's witnessed by a Presbyterian church, a Baptist minister, blah, blah, blah. They pretty much have to take that on record. So, think about this stuff. And just use your heads. It's actually pretty easy when you start out like that. And like I said, the private trust we'll talk about next, and then we'll talk about the personal trust in another video after that. But for the basics of it, again, like I said, these courts are all tax courts. They're all done on Federal Reserve notes, the transfer of, meaning that they're commercial courts. All crimes are commercial. It all ties in together and makes sense that HJR 192, Public Law 7310, proves the existence of an exemption. The fact that you have a Social Security account that's used as a pass-through account with the birth certificate, Social Security or certificate of live birth, and the county registrar's original certificated hospital statement of live birth. Those are all instruments, and they're all tied together, and they were all created because of the origin of your being born. You know, so understand your capacity of trustor, trustee, and beneficiary. Also understand, a lot of people think that, before I let you go, I want you to know that these trusts, a lot of people think you have to have 2 or 3 people involved in a trust, and you don't. When it comes to the ecclesiastical trust, the only trustee capacity that anybody would have in that situation is the witnesses that you're going to entrust to get on a stand and verify in their private capacity that they actually witnessed your words in your will. So when it comes down to those capacities, we have to understand the state's never going to have that, because they can't testify to the deceased testator's will. They know nothing about that guy, that person. So when it comes down to these trusts, you don't necessarily need even 2 people. You can create a trust by yourself, and just by the operation of law, the verification of the first-hand witnesses is limited just to that. They do not automatically become trustees. They just hold that capacity of entrustment to verify. So, and that's the uniqueness about the ecclesiastical trust. You do not have to have a trustee. You can play the part of a trustee, but yet at the time or execution, you can play the part of the trustee, drawing up a will or defining a will, whatever. But when it comes time to execute the trust of the will, that comes upon somebody else, because now you're the deceased testator. That's the only time that you would be liable if it's done correctly. Because you're not ever supposed to be liable for the property ownership or anything like that. You're just supposed to be able to have the beneficial use, and you always pass on the liability to somebody else. In ecclesiastical trust, there is no liability, because there is no benefit of another. You only prosper off of your own efforts, and those own efforts should never be a liability against somebody else. Shouldn't harm somebody else in order to be able to prosper. That's the basis of the ecclesiastical trust. So understand, a trust doesn't have to be serving upon 3 different people of man, of a category of man. It can be 1 man and 2 persons, fictional creations. Understand that stuff. So anyway, like I said, we'll talk about private trusts next video, and I hope if you have any questions, you'll ask me. I think the ecclesiastical trust is pretty simple. You just have, like I said in the previous video, you have to show the intent to create a trust. You have to name the parties of the trust. You have to show the purpose and intent and prove the validity of the trust, and express the intent. Again, like I said, that's just a simple statement of peace to carry out fair and impartiality with the rest of man, as you know them, having the same inherent and unalienable responsibilities and duties to uphold that which is right amongst all and common amongst all. Just simple verbiage that can't be rebutted. American national civilian, that's a good one to use. The admiralty courts are considered a military jurisdiction, and if you look up the military's definition of a civilian, you'll see that it's somebody that's not a part of the military. So if they're bringing a commercial action against an American national who is in his private capacity, who is also proving that he's not in a military capacity, they're bringing a commercial action in a military venue under tax laws, and using probate courts to establish wills, establish the facts of a will, so that they can execute a trust. Do you people understand how many financial, banking, trust, contract laws they're violating doing all of this? It's amazing. They're violating almost all of them. Of course it's RICO. The problem is that it's all instituted by a process. So now we have to understand that process and fix it by using that process appropriately. Like I said, a trust within a trust within a trust, just like they do. That's how they protect themselves. We have to learn how to protect ourselves the same way. So understand the importance of the ecclesiastical trust, how much power it has, and that's why we put all the other trusts within that. So we have to establish that first. Establishing that ecclesiastical trust and that separation between the military institutions, the political institutions, educational institutions, commercial institutions, because we have our own spiritual institution. We have what constitutes us spiritually. That's our own declaration of independence. Our own Bill of Rights, as you might say. Anyway, think about this stuff and realize how much it all connects to each other. Again, like I said, in order to protect ourselves, I think it's very important to learn how to construct a trust within a trust within a trust. So we talked about how to build the trust and the components of a trust in the last video. We talked about ecclesiastical trust in this one. We're going to talk about private trust in the next one. And then again, we'll talk about how that's instituted into the ecclesiastical trust. And then the next video, we'll talk about personal trusts instituted into the private trust that is already instituted into the ecclesiastical trust. So think about this tough, take notes, do some research, and I'll see you again. In the meantime, I wouldn't be doing this if it wasn't for you guys. God bless. Love you. Have a great night. Bye.